Brand new reporting reveals that the presumptive Republican nominee for president is plotting another cover-up of his role at the heart of one of the darkest episodes in recent American history, the deadly Capitol insurrection. Team Trump now trying to wash away what is an indelible stain on Trump's presidency as he asked the American people to send him back to the White House. The Guardian reporting this, quote, Donald Trump is expected to launch a new legal battle to suppress any damaging evidence from his 2020 election subversion case from becoming public before the 2024 election, preparing to shut down the potency of any mini trials where high-profile officials could testify against him. These so-called mini trials are the result of the Supreme Court ruling that Trump is immune from prosecution for official acts, even if those official acts were done in furtherance of a coup plot. They are evidentiary hearings that are intended to determine how much of special counsel Jack Smith's indictment of Donald Trump in the federal election case remains intact. As legal expert Norm Eisen put it, quote, it's going to put some of the most disturbing elements of the attempted coup on trial for the American people, for the court and the American people to consider. In theory, that could potentially include witnesses, Trump's own Vice President Mike Pence, or his former Chief of Staff Mark Meadows, for example. No surprise, then, that Donald Trump would be desperate to prevent these hearings from ever happening. Also from The Guardian, quote, in the coming months, Trump's lawyers are expected to argue that the judge can decide whether the conduct is immune based on legal arguments alone, negating the need for witnesses or multiple evidentiary hearings. If prosecutors with the special counsel Jack Smith's office press for witnesses such as former Vice President Mike Pence or White House officials to testify, Donald Trump's lawyers are expected to launch a flurry of executive privilege and other measures to block their appearances. And as for the central issue at these hearings, what conduct is covered under the Supreme Court's definition of presidential immunity, Team Trump will reportedly argue, in effect, that a coup is okay as long as the president of the United States does it. Once again, from The Guardian, quote, Trump's lawyers are expected to argue the maximalist position that they considered all of the charged conduct was Donald Trump acting in his official capacity as president and therefore presumptively immune and incumbent on prosecutors to prove otherwise. This incredibly consequential legal battle is expected to start next month when Judge Tanya Chutkan regains control of the case. Let's bring in the journalist behind the scoop, senior political correspondent for The Guardian, Hugo Lowell, bylined on that reporting. John and Harry are back with us. Hugo, tell us more.
Yeah, look, I think Trump well knows that the evidence that could come out of these hearings could be politically really damaging, but also legally damaging, right? I mean, there is the political element because the stuff about January 6th and Trump's efforts to overturn the election don't play well with voters. We know that. We see that in the polls. But there's also a legal element here, which is if prosecutors can put up some of the best witnesses they have in front of Judge Chutkan and have them testify that, no, Trump was acting in his capacity as a candidate and not the president, well, it could make prosecutors' life easier in terms of overcoming that presumptive immunity. And so they have found a way, kind of they're planning still, but they have found a way to get through this in their eyes, and that is to launch this two-pronged attack. One, to say that we don't need hearings at all, and if we do need hearings, we can do it only on legal arguments. We will be dry, boring legal arguments, and it will be kind of hypotheticals that the lawyers raise in court. And if Jack Smith really presses for witnesses, then they know they have a bigger problem, and they are expecting to launch a flurry of executive privilege motions. They want to say to the judge that the record is anew and that the previous decisions before the grand jury investigation are not binding, and that she needs to litigate the privilege issues anew. And I think that's going to be the cornerstone of Trump's effort to make sure that none of the really damaging evidence gets before the public before November.
Harry Litman, will it work?
It might. The Supreme Court opinion is not only incredibly broad in its basic articulation of the immunity principle, Nicole, but it also contains these mines and sinkholes of other principles. Here's a very big one. You may not have evidence of immune conduct to prove even your unofficial and non-immune case. So I know there are a lot of people, close colleagues of ours, are enamored of this mini trial idea, but there's a circularity in the court opinion. Jack Smith says, I call Mike Pence to the stand because I want to establish that this was, in fact, non-immune. And Trump says, wait a second, that you are not allowed to give any evidence of immune conduct. Stop the music. You must decide it first. What does Chutkan do now? And remember, this is immunity, meaning there is always interlocutory appeal. So I think at a minimum, there is grist for Trump to try to block it and then take appeals from it and to keep what exactly Hugo's talking about, which is evidence. Yes, they can do it on the allegations, and that's part of what the court talked about in the case. But can they actually bring Pence to the stand or Pat Cipollone or anyone of that nature when the court has said you can't present evidence of immune conduct to prove this case? I think there's a whole kind of obstacle course that the court has set up even before you get to that point, and it is damn tricky.
You know, John Hallman, Michael Cohen said something in the first block. He said, you know, vote for Democrats up and down the ballot if you don't like this. I mean, this Supreme Court has given the pro-democracy, pro-rule of law coalition such grist, right? Because I don't really understand all of the legal things being batted around and weaponized by Trump. But it is clear that Donald Trump on live TV had his supporters go to the Capitol, beat cops with sticks, endangered the life of Mike Pence, and he's going to get away with it. And I feel like for 8 years, we've covered efforts by the federal criminal justice system, Mueller and SDNY and Jack Smith and Tanya Chutkan and Aileen Kennett to hold him accountable. And it's a giant goose egg, not a nothing zero. No one's coming to save anyone from Donald Trump's criming except the voters. What does this, in your view, look like if successfully argued as a political issue?
Well, I first want to say, Nicole, you and I are we both have exactly the same amount of legal training, which is to say none. But I think that we both have wandered around politics and the intersection of politics and law long enough to adduce one important way of thinking about this, which is that the Supreme Court's really screwed us, you know, and I think that's the bottom line here. It's amazing that how one decision with it written the way that Harry just described, with the landmines that it's kind of strewn around, the trapdoors, beyond just the headline of it, you know, the way in which it's kind of having this kind of metastatic kind of effect on all of these potential prosecutions and efforts at legal accountability is really incredibly dispiriting. And I think it's particularly dispiriting for those of us who saw in 2020 how, you know, after 4 years of banging at the guardrails of American democracy and plowing through a lot of those guardrails and showing us all how actually fragile the system of democratic rule and democratic accountability that is America actually was, we all looked up and said, well, man, you know, I'll tell you what, the courts held. Thank God the courts held, you know, because Trump, you know, waged all these lawsuits trying to prove that the election was stolen, and he got knocked down in every single one of them. Republican judges, Democratic judges, Republican states, Democratic states. You know, we said, well, look, that's one guardrail that's still there, the judiciary. And as much as anything, what happened at the Supreme Court with this immunity ruling, it feels to me like the last guardrail has now been knocked down. And that's not to say that there aren't still judges who will uphold the rule of law, but when the Supreme Court knocks down the guardrail, that has these ripple effects across all of the rest of the judiciary, where judges who want to uphold the rule of law now have their hands tied or don't know how the Supreme Court's ruling affects them. And so now they're suddenly on uncertain ground. I know the politics of this, I mean, you know, it's a conversation for another day. I think on some level, though, watching this whole thing, it's as dispiriting to me in terms of the future of the democratic experiment in America. It's as dispiriting as really anything that's happened over the course of these last 6 or 7 years.
Right, because it's forever. I mean, a Supreme Court decision is binding until a new Supreme Court decision reverses this decision. It's done.
Yeah, and we're going to have a conservative court for a very long time.
Yeah.
Hey there, MSNBC fans. I'm Luke Russert, and be sure to join me, Rachel Maddow, Jen Psaki, Lawrence O'Donnell, Steve Kornacki, Joy Reid, and many more September 7th in Brooklyn MSNBC Live Democracy 2024. Click on the link for ticket information. We will see you there.